Good evening, and thank you so much for watching PBS Fort Wayne. I think you're going to enjoy the next half hour. I have a guest with me that if you watch us regularly here on Life Ahead, you've met him many times. Attorney specializing in elder law. Bryan Nugen is with me here this evening. Welcome, Bryan Nugen.
Thank you, Sandy. I appreciate it. Good to be here.
I bet people are starting to ask for your autograph now that you've been on so many times.
They're asking for me to get your autograph for them. Not mine.
That's pretty funny. Well, Bryan, by the way, again, like I said, this is a legal show tonight, and we're going to focus on probate. But if you have some other questions related to, estates or wills or things like that, Bryan's always very, very happy to answer viewer questions. The number is 969-2720. And here's a little tip. You can call that number that's at the bottom of the screen, and it'll be there for much of the show here, off and on. But if you live out of the immediate area, just put a 1-866 in front of that, and there will be no charge call for that. And the operator in our control room, the phone operator will answer those calls, and if you are willing to talk to us live here on the air, that's wonderful. That way, if Bryan has a question back to you, you're right there still on the phone. And actually, if you're not, it's okay, because they'll just take your question, type it up, and send it out here to the studio to me on a teleprompter. Do you see what I did, Bryan? I said, when you call, and I went like this. I still
it's
think
the old school.
I still think we have the old phones.
Yeah. That's all right.
Okay, because currently, then, if you have a phone, it's in front of you, not up to your ear. All right, talk to me about probate. First, let's define it and tell me why we're talking about that. Why is it an important subject?
Well, it is an important topic. So probate is the process, Sandy, whereby when someone passes away, if they have assets that were in their name that didn't have beneficiaries on them or weren't in a trust, something like that, there's a process that you go by where you take the last will and testament of a person, if they had a will. If they didn't have a will, we ask the court to open an estate. So we file the will, or we ask the court to open the estate if there wasn't a will. And we ask the court then to appoint someone called a personal representative.
Or PR lingo.
You got it. Sometimes referred to as an executor or executrix, but a personal representative is appointed. And then that person, when the court appoints them, is able to gather the individual's assets, determine what debts are appropriate to be paid. And there's an advertisement in the newspaper that happens. So if anybody believes the deceased person owed them money, they can file a claim in the estate. The estate, that probate process, that estate administration process can, normally it's a year more or less. If there
to settle a whole estate?
Yeah, not hard for it to be a year.
Okay.
If there's strife within the family, if there's debate about who should be receiving funds, or there's debate about if a debt should be paid, it can go well beyond that period of time. If there's a difficult asset for us to sell, it might have the estate open. So probate is a process whereby we open something with the court, we have a personal representative appointed, we advertise in the newspaper, and there's a series of events that happen after we do that. There's nothing wrong with probate in the sense that, in the end, the money gets where it should go. If you created a will where you've asked for it to go, if you didn't do that will, we do something called intestate succession that determines where the money goes. The challenge with probate oftentimes, though, is the length of time that you were asking me about, Sandy, the expense for that process to go through, right? Advertising expenses, attorney expenses, personal representative expenses. And frankly, if somebody wants to be nosy and see what you said in your will, it's a public document, so they can go and take a look at it.
Seriously?
Oh, yeah. Yep. So the will, once the estate's open.
That makes me nervous.
Well, I don't know what you're giving away in your will, but sometimes people feel very protective of that, and they don't want their neighbors or somebody else that's nosy to see that they've given this child a certain percentage, another child a different percentage, or that what charities they've remembered, or maybe somebody that they're specifically disinheriting, or how the money's going to be doled out to their grandkids over time.
But that only becomes public when?
When the estate is open. So after you've passed and we file the will with the court, then in that instance is when it becomes public, not prior to that.
Okay,
no, not
all
prior
right.
to that.
Okay, now, a lot of people have asked me, knowing that we've had Bryan and attorneys here on Life Ahead so many times, in talking about probate and getting an estate settled, that you said maybe up to a year. Now, do I understand that? And a lot of people think, well, okay, my grandfather passed away, so the will be read and everything will be distributed probably within a month or two. No. It's very complicated.
Yeah, even when we open the estate, there is a 3-month claim process. So this is a process during which folks that believe debt is owed, they have the ability to file a claim in the estate. And depending upon the size of the estate, we may have some distributions before that 3 months is over, but normally it's better to be conservative and hold off on making those distributions until we have a real handle on those debts that may exist and expenses in the estate. That's correct.
Like you mentioned, if some of your assets might be real estate, just takes time sometimes to get that sold.
Right. That's true.
But again, there's another expense.
That's right.
So you have to get all that balanced. Okay, here's another question everybody asks me. In terms of settling the estate, you said it could be up to a year, depending again on how
it's not hard to hit a year.
Is.
Honestly, it's not hard to hit a year. You have tax returns that need to be filed.
Oh, right, yeah.
So it's not difficult at all for it to be a year.
Okay, now you said advertising in the newspaper.
Right.
Okay, we have to talk about that because the newspaper circulation, as everybody's heard, is certainly down compared to what it used to be in years past. But if by law you have to put in the newspaper that so-and-so has passed away.
That's right. So
but what if nobody sees it because they don't get the paper?
So, well, as long as you're complying with the code of the state in which the estate is being opened, and generally it's a newspaper that's in general circulation within that community. So it still stands that we're advertising in the newspapers, and that's the statute requires that's where we advertise. And remember, when we're advertising the newspaper, it's just for those folks that may have a claim in the estate. So it doesn't stop the estate from moving forward. So if we had no claims, and oftentimes we don't. We do get claims on occasion, but oftentimes if folks are on top of their debts, they're on top of paying their responsibility, their financial obligations, we don't have a lot of claims in the estate.
But what if you, before you passed away, what if you had, let's say, a contractor do some work at your home and you owe him $4,000, but he doesn't see that in the paper? Then what happens? He can't go back and ask for his $4,000 if he doesn't know the person passed away.
It's true. Yeah. In order for him to file a claim in the estate, he has to file within that 3-month claim period.
Does that happen very often, that there are some that are just missed?
Isn't paid?
Why am I being negative? I don't know.
No, I think actually sometimes attorneys will wait to open an estate for a period of maybe 9 months. And the reason in Indiana for the 9 months to wait is that after you've waited that length of time, then those unsecured claims, so credit cards, other unsecured obligations, are discharged and they don't need to be paid. You still have to notify those creditors of which you're aware that the estate's been opened. If you have a claim, please file a claim in the estate. However, if we're beyond the 9 months, they're not going to have any luck at getting it paid.
And probably, I'm guessing, for most people, their expenses are monthly, so they would be getting in the mail or email invoices for whatever, their heat, their whatever, gas bills, lawn mowing, property tax. So whomever is handling the estate would be notified of those expenses. I'm talking about, I guess, the things where somebody's been hired freelance to do something.
Sure. You can't, if you're aware of a debt, you have an obligation to let the creditor know that an estate has been opened, and if you have a claim in the estate, you need to file the claim in the estate. So you do have that obligation to do so. The advertising in the newspaper that has to be done as well. So if there's somebody of which you weren't aware or weren't reasonably aware of that the decedent owed money to, they have the ability to file the claim. And that's the purpose of the advertising.
Got it.
But the advertising itself is not, that's pretty routine. So we're spending a lot of time talking about that. But that's a requirement. We can't avoid it. As far as being in the newspaper, If it's by statute, we have to advertising a newspaper that's in general circulation in the community. So that's the process.
Well, a lot of papers have information online, but is there, to your knowledge, any kind of a website that lists obituaries for all of northern Indiana?
No. Newspapers, of course, run obituaries. If I'm maybe stepping out of line here. I don't know if you could contact the newspaper and say, please don't publish this obituary. Maybe you could.
Oh,
but
okay.
They pick those up, whether or not the estate or the family requests them to publish it.
Because funeral homes have to report that to newspapers, don't they?
They do. They have, yeah. But I'm saying, I don't know if there's a means of saying to the newspaper, we don't want this to be run. We don't want this to be published. But the obituary and the claim period are unrelated.
Okay. Probate.
So I could wait, months or even, up to 3 years to probate
really?
someone's will. Yeah. So there are times that it isn't open. For example, if we weren't aware that someone had an asset that needed to be passed through an estate, so we discover an asset at some later point. A loved one had an investment, and we weren't aware that the investment existed. And then we find out next year during tax season, oh my gosh, here's a 1099 we've received. There was an investment out there. And oh, well, there is one. We need to get that dispersed. So now we're going to open an estate. So there are reasons for estates not being opened immediately after someone's passing.
That makes sense.
And frankly, when I see my clients, and I would tell the listeners as well, the first thing you need to do when someone passes away is not to rush and open an estate within 24 hours, 48 hours. It's to grieve and to recognize what's happened with your loved one, and to take a moment, take a beat for that. And after you're finished with that, after you've processed that as best you can, then that to me is the time to come in and speak to an attorney. I'll say that to folks when my clients or their family members call and say, Dad passed this morning, or Dad passed, just yesterday. What do we need to do? And generally, I'm going to give them some information about what to do. But frankly, take a beat. Respect where you are. Take care of yourself, your family. There'll be time for us to get that money distributed.
Yeah,
so take care
that
of
makes
yourself
sense.
first.
But I can see where a lot of people would think, well, they need to call the attorney right away. But that's great, because that first week or 2 weeks, you're making funeral plans. You have family coming in from out of town. It's just,
you're not tracking.
Too hard.
It's that process when someone passes, whether it's anticipated or not anticipated, it's almost out of body. You are on automatic pilot. You're not thinking clearly. It's a very difficult time. So I'd like to tell people, take a moment, respect yourself, and when you're ready, come on in, because nothing's going anywhere.
We have a call, by the way,
right.
And we always do here when you're on, Bryan. This is from James. James says, does a court assign a representative to a young person who passes away without a will, or does a family member decide? Good question, and that probably happens, James, I'm guessing, occasionally. So
when you say young person, I'm not sure if you're referring to someone under 18 or someone over 18. So if they're 18, then yes, an estate has to be open for that individual, even if they're under 18 and they had assets in their name. So we're looking at, did they have assets in their name? And it's different state by state, but in Indiana, in order to be required to open an estate, you need $100,000 or more. So if the young person under 18 had assets in excess of $100,000, then yes, $100,000 after we take into account any debts that person may have had. So if we have a net of $100,000, I have to open an estate. If you're under $100,000, we can distribute it through something called a small estate affidavit. That's a little bit faster process. We do that within 45 days of someone's passing. But simply because someone passes doesn't mean they need to have a personal representative appointed for them or on behalf of their estate. It really is just if there are assets to pass. So if, for example, someone had assets at a bank and they had a beneficiary designated on that account, I have $1 million in that account, but I have a beneficiary. It's going to my spouse or going to my siblings or going to my kids, whoever it may be. I don't need to open an estate for that account because we've designated a beneficiary, so we skip that probate process. If I've established a trust in advance, and that $1 million account was in the name of my trust. I don't need to open an estate because that trust designates where that money goes. So we don't always appoint a personal representative, just if we have assets on which beneficiary designation has not been made, or if it's not in a trust, something like that, that controls where it goes.
Now, one of the things that James said here at the end of his question was, what if a person passes away, young person or younger, whatever, passes away without a will?
Does a family member decide?
Could the family member decide? So if somebody passes away, it can't just be a brother or a dad or somebody that.
So
it can.
The statute indicates that it should be a person that's interested in the estate somehow.
Okay.
So if you're a neighbor that has, you have no interest in the estate, no interest in receiving any money, aren't owed any money by the decedent, they wouldn't necessarily be the most appropriate person to be appointed as personal representative. So if there's a family member that needs to open an estate, they have the duty to notify others that are interested, saying, I would like to serve as personal representative. Do you agree for me to serve as personal representative? If they don't agree, or you're not getting those consents back, we may need to go to court and then say to the judge, I've attempted to get folks to consent to my serving as personal representative, Your Honor. I've notified them of this hearing. If they show at the hearing, they can say why they don't believe you should be appointed the personal representative. And if they don't show, and we can prove that they got notice, the court will most likely say, yep, you can serve. Sometimes we have to post a bond. Sometimes we don't have to post a bond. If you're not a resident of the state of Indiana, you would need to post a bond in certain circumstances. If the court felt that a bond was necessary, if people were questioning your veracity or questioning that whether you would be appropriate to serve in the position as a personal representative, the court can require a bond in that situation as well. But they're not required.
Okay, that makes sense. Okay, thank you, James, by the way, for watching Life Ahead here and for calling us with a question. We still have several more minutes of the show if you'd like to give us the call. 969-2720. I have another question.
Yes, ma'am.
Let's talk about trusts.
Yep.
I know you've mentioned before that you could put some of your money into a probate trust. Am I not? I'm not.
Well,
saying
maybe
that
a living
correctly.
trust. So there are
Living trust,
revocable
okay.
trusts. So trust is a huge category.
Like an umbrella.
Like an umbrella. If I slice it, or like a rainbow, I slice it down the middle.
Okay.
Yeah, how about that? An arc. Half are revocable, half are irrevocable.
Okay.
Typically, if we're simply looking to avoid probate, avoid that estate administration process, we would use a revocable living trust. But there are other types of trusts that we use as well that would enable us to do many different things, including avoiding probate. The trusts, they're just a contract, so it's a contract that you're requesting to your attorney to prepare, and that contract appoints, in essence, 3 different players within that trust. Normally, we have someone called a settlor, grantor, trust maker. That's the client. That's the person that requested that the trust be prepared. They're the ones putting the money into the trust generally. The next position would be trustee. You can think of the trustee as the manager of the trust. So if it's a living trust, typically the individual that created the trust, that settlor, that grantor, they're serving as their own trustee. And then we have a beneficiary. Beneficiary is the one that can enjoy the money from the trust, that can benefit from the trust. And very broadly, there are 2 levels of beneficiaries of trusts. We talk about lifetime beneficiaries and we talk about ultimate beneficiaries.
What's the difference?
So a lifetime beneficiary is during the lifetime of the settlor, the grantor, who enjoys the money, who can benefit from the money in the trust during their lifetime. After they've passed, the ultimate beneficiary or beneficiaries would be the person that are receiving the assets from the trust at that point. So if I've said, during my lifetime, my spouse and I can enjoy this money, we're going to use it to live, and we're going to spend it as we are wont to do. If we have expenses, we can take money out of that trust and pay those expenses. Then at the time of our passing, I'm saying money's going to go to my children. It's going to go to PBS, right? We're going to make a donation to PBS and another charity. Those are the ultimate beneficiaries. So ultimately, they would get the money out of the trust after the passing of the settlor.
Okay, all right, that makes sense. And you know, I know we're making it sound complicated here, and it is for him. It's not for us if we do go to an attorney because they know what to do. But we try to simplify things for you here on Life Ahead and give them information
Sure,
or education for your decisions
that's the whole point of being
to
here.
make. Yeah. What would be like a key thing people need to know about trust? Do you have to have a certain amount of money to set up a trust?
Yeah.
And what happens if you've used up all that money?
Well, the trust is it's like an envelope that holds assets that you put into the trust. So it could hold your real estate, it could hold a brokerage account, checking account, savings account. There is no magic number for amounts that you put into the name of the trust. It could be a nominal amount, it could be an exceedingly high amount. It really is, what do you want to get accomplished as a client? What is it that you want to get accomplished? Is it important for you, as we were talking at the top of this program, to avoid probate because trusts permit us to do that? Is that important to you? But also, there are other things that trusts can do. We can use trusts if someone is a special needs individual and if they hold money in their own name, they would lose their public benefits, their Medicaid, for example. So we might use a trust to shelter that money for them. Again, it's just an envelope, a box that holds assets, and then there are rules that go with that. So no, Sandy, there's no minimum or maximum that we set up trusts for.
Okay.
It really is, what does the client want to get accomplished?
Okay. And you've talked before, when we've talked about estates or wills or whatever, you've talked about, I'm learning these terms that you've
All right.
been using here, legal terms. TOD, transfer on death,
Right.
that you might state that a certain asset is a transfer on death to somebody. What's the advantage of that?
So a transfer on death is a beneficiary designation. So I've said that a couple times tonight. A beneficiary designation, you're indicating when I pass away, where does this asset go? So on that asset itself, you're designating who receives it. So in Indiana, we have TOD, transfer on death deeds, so that I can convey my real estate to an individual at the time of my passing. They complete an affidavit after you've passed, record that, and the property's in their name alone, avoiding probate, avoiding the need of the trust in that situation. I could put a beneficiary on my checking account, on my savings account, on my brokerage account, IRA. So when I pass, we look at the individual's name that we've put on there, and it automatically goes to them. We're avoiding probate, avoiding that entire process. So that TOD that you were asking about, transfer on death, sometimes you'll see institutions call it POD, payable on death. Sometimes you'll see beneficiary designation, but in essence, they're all the same thing.
Okay, transfer on death and payable on death, basically
Synonymous.
the same.
As far as the deed is concerned, it is specifically called a transfer on death deed. However, you'll come across institutions that call those beneficiary designations different things. So if you were to simply say POD, the institution that you're dealing with may say, POD, you mean a beneficiary designation, or you mean a TOD, transfer on death?
Yeah.
In essence, they're all the same, though. You're wanting to pass those assets after you pass,
Got
you
it.
die, without going through the probate process. Maybe you don't have a will. You have the transfer on death beneficiary designations. I do like to add a caveat to that. There's nothing wrong with using it in the right instance. However, when you do those beneficiary designations, it skips what you say in your will. It skips what you're saying in your trust. So that if, for example, you said, I want my grandchildren to receive this, but not until they're 25. If you've designated a grandchild as a beneficiary, it goes to them. If you've designated your children as a beneficiary and they're minors, it goes to them, of course, until they hit age 18. So whoever the guardian is for them would be managing that money for them until they hit 18. But so we have to be a little cautious with those beneficiary designations. They're not right in every instance. For example, owning real estate with someone else is always a challenge. So if you've said, the farm, I'm going to convey the farm to my children. I've got 3 kids and I wanted them all to receive the farm. So now the children now have the farm in their names. Maybe one wants to sell. Maybe one is ill. Maybe one has debt. So now the others are in business with their siblings because that's how the transfer on death designation happened.
So are you suggesting that people avoid having more than one owner of an asset?
No, I'm cautioning that real estate can be a tricky one to own with someone else. If I have an account where I've got more than one person designated on it, 2 children, 3 children, 5 children, it doesn't matter because they get their one half, 1/3, 1/5 of that account. Easy. It's that real estate. My experience has been that I'm going to give the lake cottage to my kids. One child is up there all the time, maintaining it, doing a great job. The other child, their kids run up on the weekend, have a party, and they're going a little crazy, and it's frustrating. So I'm just cautious about that, and when I'm speaking with my clients, I like them to be aware of that. But they need to make the decision. Ultimately, the attorney doesn't make the decision for them.
Right.
It's just something to be aware of.
Okay, good tips, certainly. Okay, a lot of food for thought, if you will. Bryan Nugen, thank you so much.
I appreciate it. Thanks for having me on.
I'm sure you'll see Bryan with us again here on Life Ahead. Meanwhile, every Wednesday night, we're right here in PBS Fort Wayne and bringing you, hopefully, new topics and new guests every week here on Life Ahead. Have a great night and stay healthy and stay happy.
The preceding program on PBS Fort Wayne was made possible in part by
Nugen Law, specializing in estate planning and elder care law, emphasizing independence and quality of life. Serving Indiana, Ohio, Michigan, and Florida. More information at nugenlaw.com.